Okay. Oh, I just turned it off. Alright, so I'm going to talk about the motion for discovery by the state again. Now, I refer to it as the mental disease discovery, but it's gotten more serious. It's not a matter of mental disease now, as it is this, and it's turned into something much more serious on their part that I mean I've never experienced before. So it's an order. This has been transformed into an order by Judge Owsley, and what the prosecutor is demanding, pretty much, and that Judge Owsley is claiming that I have failed to provide, since Prosecutor Benjamin claims that I haven't provided anything. He's saying I have YouTube videos, but I haven't provided any discovery. And it involves, on Part A, City of Natchitoches moves the court to require defendant to produce the following defense discovery pursuant to applicable law. Okay, and the applicable law, since he doesn't mention it, I mean, well...
Just communication between her and her daughter about who was getting the 5-year-old this morning.
Books, papers, documents, video, photographs, tangible objects, buildings, places. It's a blanket. And I said it's a blanket demand. Control anything, therefore anything in the possession or control of defendant, and that the defendant intends to use in evidence at the trial. This is his demand. It's not or that I intend to use. And the judge is totally behind the prosecutor. So they're demanding I give, like, what? I surrender my car? They're just gonna take my car as evidence? I mean, they've gone way off the deep end. I mean, they have discussed talking about my YouTube videos, but the YouTube videos stand as they are. I mean, they're asking for, like, beyond the YouTube. They're asking for they're asking for, like, another copy of the YouTube videos or something. It's not clear. So oh yeah, that's a mental disease. Okay, so whoops. Oh, this is not going good with one hand. Okay, and the ending, which is, for the purposes of this demand, the state avers that the time, date, and place at which the alleged offense was committed was as follows. Okay, yeah, and they're referring to things that are exclusively tied to that. Okay, and yeah, this is on the part of my prosecutor. Now, on my defense, although this is the order, I have to provide the discovery demands. I have to show that the defense, I have to show why I shouldn't be ordered to provide discovery. And then Judge Owsley signed that, and that's when I argued about my Fourth Amendment rights, Fifth Amendment rights, and then on February 15th, wait, oh yeah, it was signed on the 9th. On February 15th, it's Judge Owsley sounded like he was just like up for the just only stuff that's going to be brought as a part of my defense in trial, and that was it. It's like, then later on March 7th, okay, now this is my objection to the barred time limit, and this apparently is an old rule Article 521A now. It's changed. This is an old 2020. 2020 is considered an old rule now. They made a sudden change. It's unsigned here. And now instead of 15 days after the arraignment, it's 30 days after the request for discovery, something like that. Okay. Okay. And then of course, Judge Owsley likes to just bring them into court, and that's the orders he likes to write. All right, and then so I said it was time barred. This was the prosecutor's argument. Ruling denied discovery that was previously addressed or contained in this court ruling relative to the interlocutory issues and rules. Moreover, reassertion of the issues is tantamount to relitigating the issues, which is barred under the theory. So he's saying that our bar argument is barred under the theory of res judicata. Defendant raises issues that are interlocutory and should be denied once again. And Judge Owsley then further argues orally on March 7th that this was an old time bar. I'm referring to an old time bar in 2020, up to 2020, Article 521A was the 15 days after arraignments, but now it's changed. So at some point, it wasn't clear when. At some point after 2020, this was pushed. It was changed to 30 days after, like a request or something. So this is the this is the back and forth, and Judge Owsley has doubled down. All right, he wasn't so clear. The courtroom was full on February 15th, but then it wasn't so full on March 7th. So then they doubled down a little harder on requiring me to give evidence, some kind of evidence, to the prosecutor, and it doesn't have to even be presented as a part of my defense. So they're asking for me to present stuff that's going to that could possibly implicate me. If I'm not going to use it as a part of my defense, they still say I should submit evidence. And they're referring to YouTube videos, and it sounds like they're not able to get these YouTube videos themselves or something. It doesn't really make sense. They have good access to these videos like everybody else, yet they're not happy with their access to the YouTube videos. Like they're implying there's something more than the YouTube videos. All right, but they haven't made any arguments. See, that's the thing. I think the burden's on them to make arguments as to why the YouTube videos that are available to everybody are not good enough. And I guess I failed to make a stronger argument about that. But it just sounds so ridiculous on their part to make these demands that I was more in shock to hear them to talk about how they know about videos on YouTube. Like, the YouTube videos are teasers. The YouTube videos stand on their own, yet they apparently don't stand on their own. I don't intend to use them, yet they still want like more. And because it's an order from Judge Owsley, it sounds like I could go to jail over stuff that I have over like not having stuff that I can't present. I have nothing to present them. Because I have nothing to present them, I'm going to jail. That's that type of thing. It's like walking into Walmart and then leaving without buying anything, and the front door checkers demanding I show them a receipt. even though I didn't buy anything. I look at the coffee maker or the blenders, and that's it, and then walk out, or try to walk out, and then they demand a receipt for looking at these things. I just don't know how any other way to look at it. But this has now gotten ridiculous to the point where Judge Owsley's making an order about this motion for discovery by the state. I don't know how to handle it, except I'm telling the prosecutor it's all available for everybody on YouTube. What is your problem? Let's meet. All right, that's all I could do is say, let's meet and talk about this. And of course, my prosecutor doesn't want to meet, so then we have that issue. It's really a strange situation at the moment.